Dear colleagues, as to my information, that is the high time to start the present panel. That is the panel about the legal protection of farmers. On behalf of the members of the present group, I would like to express our gratitude that we can be here, of course, especially to the organizer of the present event. And personally, I would like to emphasize that it considers a great honor for me that I could be the leader of the present panel, and I would like to express my gratitude to the members of the present panels that we could collaborate with each other. Thanks. After that, I would like to continue the order of my presentation. At the beginning of the present research, there was a list of challenges, problems. There were 10 questions. And the first question was for us how to build a kind of monograph. Finally, we found two potential approaches. One of them connected to the classical topics of agriculture issues, and another one connected to a modern approach, maybe based on the sustainable development. At the end, our decision was to build a monograph based on the classical approach. Taking it into account, my presentation also connected to this approach, and the topics of my colleagues have a similar or represent a similar idea. As to this classical approach, I focused on acquisition of agricultural lands, but I emphasized the international and EU law aspects of these questions, and I tried to assess the situation at international level and EU level, and taking into account that the question was that to provide the Lega Ferenda proposals as well, I did it, and I imagine a potential debate in the next European Parliament about the future of Europe, and taking into account this potential dream, I did my best. Okay, my working hypothesis, because if you want to, or I want to assess the situation and to provide the Lega Ferenda proposals, I have to find a basis. And my basis was the concept of the given countries, that is the concept, agriculture acquisition concept of Poland and Hungary. Taking into account the fact that in Central European region, Poland and Hungary regulate the acquisition of agricultural land in the strictest way, I could do this because last year we have a project in which we compare 8 countries' legislation, and the strictest ones, they were the Polish and the Hungarian regulation. Therefore, as to the international and EU affairs, I based my assessment on this characteristic of the Polish and Hungarian regulations. That is, it is important for both countries to maintain their regulatory freedom at international and EU level to the fullest extent possible. That was my starting point. And after that, I started an analysis with international issues. I focused on UN documents, on human rights regimes, and also on investment issues as well. There were some antecedents before this research previously analyzed by different researchers. As to the UN level, I have to emphasize that that is a soft law document. Soft law document is not a compulsory document. However, nowadays it is a tendency that sometimes soft law documents somehow became some hard law. Therefore, I think it's always interesting what are in these soft law documents. First of all, I have to emphasize that This is the first international soft law document on land acquisition, these voluntary guidelines. And it's about food security, partly food sovereignty issues. And what was the main message of this guideline? The responsible investment is important, and also important the rural communities, which should be the subject of a good and responsible investment. And another issue, that the traceability of the ownership backgrounds. And I think these issues, that the maintaining of rural communities and the transparency and traceability of the ownership background, these issues are important for the Hungarian legislator and also for the Polish legislator. As a kind of note, I have to say that it was interesting for me that the Food and Agriculture Organization of the United Nations document the rural communities, and the concept of the rural communities nowadays is closer to the Polish and Hungarian approach than the new rural development strategy of the European Union. It's interesting. However, as a kind of conclusion, the contents of this kind of documents can be useful for Poland and Hungary. However, please never forget that if we accept and we refer these documents, in my opinion, it a little bit can affect our sovereignty, because however the land acquisition issues, they are extremely important aspect of the sovereignty. As to the regional human rights regime, and especially the European Court of Human Rights cases connected to land acquisition, there are numerous cases, some of them quite specific Central European issues. There are numerous affected human rights. As to the characteristic of the land acquisition regulation of a nation, especially the right to property can be interesting. I have to emphasize that this right does not guarantee the right to acquire property, which means that no one has a substantive right to acquire property. Individual countries, for example, Poland and Hungary, of course, they have great freedom to develop their own acquisition rules. As to this level, as to this human rights level, however, I drew the attention that in the European Union, taking into account the Charter of the Fundamental Rights, the European Union started to establish its own human rights regime. As to the Polish and Hungarian approaches, I think a similar approach at European level as in the case of European Court of Human Rights, it can be proper, acceptable for us, or we should support this kind of development. That's all. Therefore, I think, however, for me, it's always a question: why was it a necessity to establish an independent human rights regime in the EU? But now I do not want to go into details. And as to the international investment law regimes, in the last decade, I think it was an extremely important issue. In my opinion, it's connected to the unsuccessful developments as to the World Trade Organization Doha round. That is, they could not close this round. Therefore, the bilateral investment regimes became more important. And that is the reason why the European Union and the member states, they started to sign these treaties with the potential commercial partners, Singapore, Canada, Japan, South Korea, and so on and so on. And the great topics, of course, the direct investment regimes with the United States and China. What is the situation? Please never forget that the investments among the member states, of course, this is an EU law issue. Therefore, this topic is merely about investment coming from third countries. And as to the Lisbon Treaty, EU gained exclusive competence on foreign direct investments. But never forget that nowadays these treaties. They also affect not merely foreign direct investment issues, but also other issues. And that is the reason why the member states have an opportunity and competence to be involved in these negotiations and in the adoption of this kind of treaties. However, the names of these treaties can be absolutely colorful. Similarly, the approaches of land acquisitions in these treaties, sometimes they connect it to investment, sometimes to services, sometimes to freedom of establishment. It's quite colorful, the situation, which is a kind of conclusion as to the previously concluded and signed investment treaties that Poland and Hungary have reservations about closing their markets to cross-border land acquisition. And therefore, taking into account the Polish and Hungarian approach, it is very important that Poland and Hungary also express their reservations regarding future treaties with investment provisions, so that the protection of their land acquisition regimes remains closed. Therefore, it's a kind of proposal taking into account the present legislation concept. And one of the sensitive issues connected to this investment treaties, they are the applied dispute settlement procedures. Therefore, I think it's extremely important to focus on them as well. Okay, that was the international law, and now I would like to continue with the EU law aspects. An absolutely new developments at the field of the EU law. These soft law documents of EU law concerning land acquisition. You know, because previously there were no similar documents. I can recall a situation when I asked the representative of European Union Commission that please give something about your interpretation, and they were absolutely against to give anything about this issue. But now here you can see that there is an opinion, a resolution, interpretative communication issues. Therefore, it's something new thing, and I previously expressed my interesting approach as to the soft law documents. They are soft law documents, and of course they can become, for example, something hard, for example, via a decision of the Court of Justice of the EU. Therefore, they are important. I dealt with this issue, however, in one of my previous research. As to the primary law sources, they are the typical frameworks for this land acquisition. And now there is a kind of, I don't know, new wave that maybe a secondary law level can be also essential. However, as to the framework, there are the member states' competence how to regulate the acquisition of agricultural lands. It's based on two pillars. The first, EU negative integration model, prohibitive rules, especially the free movement of capital. That was the typical thing in the last 1.5 decades. And on the other side, the EU positive integration model, especially referred to the treaty functioning of the EU, the CEP, the Common Agriculture Policy rules. In a given sense, we can consider the previously noticed soft law documents as something valuable for Poland, for the Polish and Hungarian approach as positive. However, as to the Commission document as more focused on a negative integration model, it's something interesting. And nowadays, a new wave of the framework of the EU law regime connected to human rights, of course, the fundamental rights, the Charter of the European Union, especially the right to property. And now we have a new case in which land acquisition issues was assessed via the right to property. This is a Hungarian case, of course. We have numerous cases in connection with our land acquisition rules in front of Court of Justice of the EU. Therefore, the Hungarian lawyers said they are quite good experts if you have any questions in connection with this. But I have to also draw your attention that there are also some changes, maybe now new changes, new waves as to the interpretation, the negative integration model as well. In one of the case, it was in connection with the Latvian case. The Court of Justice of the EU put more emphasis on freedom of establishment. Is not something new, because I noticed that in the last 1.5 decades, the free movement of capital was in the focus. That previously, the freedom of establishment was also part of this. It's a standard change, in the practice. It's a quite dynamic, in my opinion. And one interesting aspect of this decision also that they referred to the directive. This 2006/123. Okay, and some interesting questions may be connected to this interpretation era. If you like, for example, migration issues, and you are a lover of this hot topic, please never forget that what CEP, as to the CEP, what the concept of the rural communities, what does it mean? I think there is a change as to this document Cork 2.0. This is the new rural development strategy of the European Union. And from a traditional way of interpretation of concept of rural communities, there is a change to another one. Or if you are a lover of the rule of law issues, I think the soft law documents, they are quite valuable field to interpret them. Whether they are good or not, of course, it's provide a proper field for you for debates. I previously mentioned that Hungary is it's a real treasure of the cases in front of the Court of Justice of the EU. One of the cases I think extremely important, can be interesting also for the Polish lawyers, this infringement procedure, because it is also about the acquisition of land by legal entities. However, there are other issues as well, but I think that the previously mentioned infringement procedure is the most important thing. However, at European level, in connection with the European Council of of Agriculture Law, this is a non-governmental scientific organization here in Europe. And we have some debates about the potential future of the legislation of acquisition of agricultural lands. And later we continue this debate also in Hungary. How should we, which kind of position could be useful for Hungarians? It means, to maintain our approach as to the acquisition of agricultural lands. Our system is quite strict in this sense. Therefore, there are some debates. The abbreviation, it means that Journal of Agriculture and Environmental Law. This is a journal. If you want, of course, you can find articles about this topic. But as to my Delega Ferenda proposals to this topic, in my dream, during a Future of Europe dispute, if the member states are ready to amend the existing primary law sources, I think that it could strengthen the European integration if this question, acquisition of agricultural land, could be subject of reservation. Taking into account it could be the best respect the sovereignty of member states. And for me, a stronger Europe, it does not mean that every aspect of life we should be closer and closer and closer. Maybe a more efficient Europe, sometimes it's when the ties are not so strong, but can provide more flexibility. If my first steps, dreams could not be acceptable for decision makers, I could imagine a kind of amendment, even the Treaty on the Functioning of the EU, and to regulate this issue in the treaty, especially in connection with the common agriculture policy, strengthening the positive integration model approach, and implementing this issue that the transparent ownership structure is extremely important, and I think via legislation, national legislation, we could provide this option for the member states if they want to regulate. It's not a necessity. Of course, there are numerous countries here all around the European Union which use a liberal approach. I think it's okay if it is their decision. But for others who want to operate a more strict regulation, it could be nice if we could somehow maintain this kind of regulation. Therefore, transparent ownership, the limitation as a potential limitation of the acquisition of land by legal entities, or the maintenance of traditional rural communities. Unfortunately, nowadays, it means from Hungarian position. Now we have to put some words in front of the rural communities, and the traditional thing. It's important from a Hungarian point of view. Support for family farming and the small-scale producers. Dear colleagues, thank you for listening. I was honored for your attention. And now I would like to call my colleague from Hungary, whose affiliations connected to the authority of Hungarian Competition Authority, Dr. Martin Csirszky, to deliver his presentation.
Which one? Dear professors, dear colleagues, thank you very much for having me here and being able to deliver my presentation concerning the research results from the research group of legal protection of farmers. As you can see, my topic will be competition, sustainability, and the agricultural sector, and I was trying to discover these interrelated topics from the viewpoint of agricultural producers. However, I would like to emphasize that my research results led me to conclude that the question whether we support agriculture or we try to or we do not support agriculture and the sector and producers is basically a value judgment, and there are many more factors to be taken into account and to be taken into account by, I would say, legislation and politicians, whether they will support the agricultural sector and they will help agricultural producers to realize better profits. So basically, my starting point was that there are many problems that producers face, and these are problems which cannot be cured, I would say, because these are the problems that originate from natural conditions. And as you can see, the first one is that agricultural production is vulnerable to weather and climatic conditions, and that's the reason there is no predictability of production, and producers are not able to predict whether the quality and quantity of their products will be sufficient, will be of high quality, and this places them and this puts them in a very difficult position. So this comes with the situation that there is more difficult to find a stable equilibrium position between supply and demand, because sometimes there are a higher quantity and a better quality of agricultural produce, and in other years there are much worse performance in this regard. This comes with another layer which results in the situation that the prices of agricultural products are volatile, and it comes from the so-called cobweb cycle that the large amount of time passes between the decision to produce something and its arrival on the market, and price fluctuations happen because of this situation. All of these mentioned problems contribute to the fact that producers, although they are the ones who try to sell their product, they are not the ones who determine the prices. They are the ones who suffer from the lack of bargaining power, and they are not able to enforce their interests, and they are price takers and not price givers, and it is a situation which comes with the deterioration of their profits. So basically there are many types of buyer power abuses, meaning that when the producers aim to sell their products, processors, retailers, wholesalers are in a much better position to determine the contract terms, and in many cases producers have to make a take it or leave it decision, and this puts them in a very difficult position. So I would also say that the producers are the ones who are the risk absorbers of the food supply chain. However, I think that they are the ones whose added value is almost the highest in the food supply chain. Since the 1990s, there is pressure from two directions concerning agricultural production. One is market liberalization, which comes from an international point of view, and the so-called agricultural agreement was adopted within the framework of WTO. And on the other hand, producers need to include sustainability considerations for the sake of receiving state support. And these two pressures are very intensive since the 1990s, and it makes their situation much more difficult than before. As you can see, there is an I call it uneasy complexity concerning the relationship between sustainability, agriculture, and competition, and there are many questions to be posed and to be answered, and this is a situation which is so interrelated and so complex that, as I told in the early sentences of my presentations, that maybe it is a value judgment to decide whether we support agriculture or not. These are the questions that should competition law contribute to sustainability at all. Another aspect of the situation is that there are different aims for competition law and the agricultural sector. And the third aspect of this whole interrelatedness is that which agricultural methods are sustainable. When we look at the legal landscape of these interrelated questions, we can see that basically agricultural policy with producer welfare at its core is the winner of the situation, because there are many derogations for agricultural producers and there are many exemptions for agricultural producers that aim to help them in the process of selling their products. However, of course, there are competition policy considerations with consumer welfare score, and these are not in line with one another. When we look at the situation that when we go to when we go shopping and we see that there are higher prices for some kind of fruits or vegetables, we can feel that it is not worth it. But the higher the price you see in the supermarket, it is possible that the higher price was paid for the farmer for that given product. So there is a kind of contradiction between producers and consumers in this regard. Of course, producers want to sell their products at a higher price, but we consumers, when we go to any kind of supermarket, we would like to buy our food cheap, at a cheap price. Concerning the legal framework of this topic, we can say that there are conventional competition rules, I mean antitrust rules, that regulate the framework of the situation between agriculture and competition law. These antitrust rules, as the so-called exception norms that I mentioned, it means that agricultural producers can combine their forces and they won't be punished for breaching the prohibition of anti-competitive agreements. Added to this, there is a new exemption at EU level which aims to promote sustainability agreements, and this comes with the same legal solutions, meaning that certain sustainability cooperations between producers are not enforced and not enforced by competition authorities, because there is an exception norm in this regard. On the other hand, there are so-called trade regulation rules which go beyond the scope of conventional competition law, antitrust law, and these trade regulation rules cover a broad spectrum of unfair trading practices, and these are so-called specific norms because they are specifically adopted for the agricultural producers for the sake of their protection. As you can see, the system consists an ex-post protection system with some limited antitrust exemptions that I mentioned, and the prohibition of unfair trading practices. Ex-post protection system means that a violation of law happens, and after that enforcement authorities go after the violation, but the situation cannot be preventively handled. So my next slide, you can see the three-pillar system concerning the first pillar of the ex-post protection system, the limited antitrust exemptions, and basically these are highly harmonized at EU level, and there are three of them: Article 209, 10, and 10A of the so-called Common Market Organization regulation, and it covers different aspects of anti-competitive agreements that are exempted from the prohibition of competition law. The new provision that I mentioned, which aims to handle sustainability agreements, has been codified as 210A of the Common Market Organization regulation, and it aims to give a helping hand for farmers to consider and to adopt sustainable practices without being in a danger that they will be, I would say, prosecuted by competition authorities for breaching the prohibition of anti-competitive agreements. The second pillar of the ex-post protection system is the so-called prohibition of unfair trading practices in the food supply chain, which which comes from an EU directive that is implemented by all member states. There are different institutional solutions, but basically the whole directive is based upon a minimum harmonization consisting of a blacklist, meaning that those practices in the blacklist are per se prohibited, and there is a gray list which can be which, if agreed by the parties mutually, it can be exempted from the prohibition of unfair trading practice. Because of this minimum harmonization and the different context of the member states, there are different ways of and different enforcement experience in this regard. For example, Hungary already had for 10 years a kind of enforcement mechanism before the EU directive had been adopted. And another example for the different institutional solutions, for example, in Hungary, totally independent and regulatory agency enforces the mechanism, the so-called National Food Chain Safety Office. However, in Poland, it is the scope of the Polish Competition Authority to enforce the prohibition of unfair trading practices. The most significant conclusion of mine was that despite the fact that there are both some antitrust and trade regulation provisions exclusively applying to agri-food markets, the root cause of competition-related problems in agri-food markets is not addressed at all and or in time. And the solution would be an ex-ante enforcement mechanism, so we should prevent the creation of market situations in which the abuse of buyer power, be it bargaining or monopoly power, cannot come to the fore, and it would be crucial to the attainment of agricultural policy objectives. I have some proposals. I think we should introduce a sectoral merger control, lower thresholds for dominance, and also clarifications for existing rules, and seizing the redundancy of the legal acts in force. You can see the cascading nature of the system which I propose concerning the lower thresholds of the abuse of dominance. I would not read it loudly, but it would be easier to go after certain buyer power abuses if the threshold of dominance would be lower. Basically, my final words would be that there are many aspects whether we support agricultural producers. From a politician's point of view, for example, there are many research results, political economy results, that it is worth for politicians to support the agricultural sector because it comes with more votes than if the given politician would not support the agricultural sector. So, for example, from a political point of view, it is worth supporting the whole sector. From an economic point of view, of course, from a microeconomic approach, I would say that it is not worth supporting the sector because maybe bigger farms are more efficient. They can include and they can use economies of scale, economies of scope, and maybe bigger farms and not family farms are more able to provide food for the people. However, as a last conclusion, I would say that because of the already mentioned rural communities, the multifunctional approach that should be adopted concerning the agricultural sector, and the realization that not only economic contributions come from agricultural producers, but also other environmental and traditional aspects should be taken into account. I think our moral obligation to support the community of agricultural producers, and of course from many aspects it can be disregarded or seized, but it is, I think, and it's my own opinion, that it is a moral obligation to retain the level of production. Thank you for your attention.
Dear Dr. Czirski, thank you so much for your contribution. In my previous speech, I referred to the fact that as to the monograph of the present group, we chose a traditional approach in which we focused on agricultural lands and holding acquisition issues on one hand, and on the other hand, we focused on the protection of producers in commercial issues. And Dr. Czirski presentation and contribution focused on this aspect, similarly to the contribution of Professor Adamus as well. However, in the program you can see his name, but unfortunately, taking into account to a given health problem, now he cannot be here, or maybe we hope as to the end of the present panel, maybe he can make a kind of connection, but who knows. Therefore, now we are going to continue the present panel without his oral contribution. Dr. Czirski and Professor Adamus focused on the agriculture producers and their commercial issues, but now we would like to continue our panel with agricultural lands and holdings issues. And my colleague from Hungary, from University of Miskolc, Dr. Hornyak, is about to deliver a presentation about the Hungarian legislation. Dear colleague, the floor is yours.
I'm Zsófia Hornyak from the University of Miskolc. I'm an assistant professor, and as you can see in my slide, I will speak about the regulation of agricultural lands and holdings in Hungary, but it's quite a huge topic. So in this presentation, I will focus only the acquisition of agricultural lands and holdings, but only a few focal points. I will speak about a few points, and I think these points are these situations which can be interesting for the Polish and the Hungarian legislator as well. So at the end of my presentation, I will give some de lege ferenda proposals, and I hope it will be helpful and interesting for the Polish legislator as well, not only for the Hungarian legislator. First of all, I would speak about the basis of the Hungarian regulation. Because of the agricultural transfer situation, we can say that the agricultural land is in the basic of our regulation, not the holding, as for example in the Western European countries. But in Hungary, we can say that we doesn't have a holding regulation in a classical way, but we have some kind of regulation, some acts about the agricultural holding. For example, the Act on Family Farms and the Act on Transfer of Agricultural Holdings. It means that we are in the way for a classical agricultural holding regulation, but at the moment, the basis of the Hungarian agricultural transfer regulation is the agricultural land. And when we speak about these two acts, Act on Family Farms and Act on Transfer of Agricultural Holdings, we can say that not so clear what was the legislator's intention, because we can't say that we have a clear, exact agricultural holding definition. So it's a little bit different in these two acts, and I think this is one of the main problems. But I will speak a little bit detailed in a little bit later. And now I would like to highlight one point when we speak about the acquisition of ownership of agricultural land, and this is the succession regulation, because in this area we can see a big lack from the legislator. As you can see, the Land Transfer Act is our main agricultural transfer act, and the scope of this act shall cover the acquisition of ownership of land under any title and by any means. But here is an exception, which is the intestate succession. It means that we have to use the general rules of the civil law for the intestate succession of the agricultural lands. But the testamentary disposition is under the scope of this act. It means that so the purposes of this act and the purpose of the Hungarian property policy is to eliminate the fragmentation of estate structure, and the person who will acquire the ownership of the land has an agricultural expertise. So when we speak about the testamentary disposition is under the scope of this act, but the intestate succession is not under the scope of this act. Till 1st January 2023, because from this date we have some special rules when we speak about more coerce. If there are more coerce by the intestate succession, in the case of the intestate succession, we can say that we have a new act from 2020, which is the Act on the Liquidation of Undivided Common Ownership of Land. And in this act, we can see that if there are more coerce in the case of intestate succession, there are some special rules for the intestate succession of agricultural lands. But the main aim of these rules are to eliminate the undivided common ownership of the land. So it means that the main goal of these rules are to keep the land in one hand as a unit, but there are no condition for the agricultural expertise, and I think it's not a good point. So the problems with this succession regulation is that it's a very patchwork regulation, it's not coherent, and the regulation of two ways, it means the intestate succession and the testamentary disposition are along other principles. And I said earlier that we doesn't have a holding regulation in Hungary in a classical sense. It means that for the agricultural holdings, we doesn't have succession rules, but we have a new legal institution from 1st January 2023. It's not for the succession, so it means the transfer of agricultural holdings inter vivos, but it's only for a very special case. It does not cover all the transfer situation for the agricultural holdings. It facilitates the generational change, and the main aim is to keep the agricultural holding in the hand of the family. So it's this this farm transfer contract is the new special legal institution, and I would like to speak a little bit about this contract because it's a very new institution in the Hungarian legislation, and I think it can be a good model for other countries as well. And the main aim of this act was to lighten the administrative burdens and make as easy as it possible to this whole situation. So when the owner of the farm, who is a little bit elder, so it can be as easy as he can give the ownership of the farm to the next generation. So the subject of this transfer situation are very limited. It means that both the transferor and the transferee must be primary agricultural producers or individual entrepreneurs engaged in agricultural and forestry activities. When we speak about the transferor, who is the owner of the farm, he or she has to reach the age limit for retirement. All will reach it within 5 years from the conclusion of the contract. The other subject is the transferee, who is under 50 years and at least 10 years younger than the transferor. And another very important condition that this transferee has to be in the chain of relative to the transferor, or have been employed or in other employment relationship for at least 7 years with the transferor. And only one person can be the transferee. So these are the conditions of the subjects. And when we speak about this special type of contract, this farm transfer contract, we can say that there are 4 types of the contracts. So the farm transfer, sale contract, gift contract, maintenance contract, and life annuity contract. And the law also recognizes the mixed types of these contracts. But what is very important, that the legislator give a very good possibility that the parties can take a cooperation period in this contract. And in this cooperation period, the farm transferor and the farm transferee can jointly operate the farm. But the transferor is the owner till this in this cooperation period, and the transferee helps him to manage the whole farm and this whole situation. This period can be for maximum 5 years long, and here can we see this lightening the administrative burdens in this situation. So it means that after this cooperation period, the transferee replaces the transferor in the civil law contracts relating to certain elements of the farm without the consent of the third party remaining in the contract, and the transferee shall replace the transferor as the holder of any prior authorization required for the pure pursuit of the economic activity related to the farm. And here you can see my de lege ferenda proposals. And I would like to highlight 3 very important proposals. And the 3 area which I would like to highlight is the agricultural holding regulation. The second is the regulation of agricultural succession. And the third one is the transfer of agricultural holding. And I try to make these proposals for the Polish and for the Hungarian legislator as well. And when we see the first point, I think that by the agricultural holding regulation, we have to highlight that we need a unification of the concepts of the holding. And I think it's a problem for the Polish regulation as well, that there are more acts and more difficult holding definitions. And I think we have to unify this definition, what does it mean, the agricultural holding? So I think it's a proposal for the Hungarian and for the Polish legislator as well. After that, we need to establish a unified holding regulation, and we can only after that fit the rules for the acquisition of ownership of land to this whole unified holding regulation. My second point was the regulation of agricultural succession. And when we speak about the Hungarian and the Polish regulation as well, we can say that at present there are no coherent sui generis agricultural regulation for the succession. And because of the national regulation, so the special conditions of the national regulations, I can give only general proposals. I think these general proposals can be interesting for the Polish and the Hungarian legislator as well. So I think we need a complex system, and this complex system should be established where the rules of the testamentary disposition and the intestate succession are formulated along the same principles. And the sui generis succession rules for both the holding and the agricultural land as well should be laid down in such a way as to avoid fragmentation of the holding and the land in the succession, and to take into account the succession of a person with competence, special skills, and experience in agricultural production that will enable proper management. And my third point was the transfer of agricultural holding. And I think, so it's a new special legal institution in Hungary, and I think it can be a good tool to help the generational change in the agricultural territory. And the main aim of this institution is to facilitate the generational change and lightening the burdens, the administrative burdens. Of course, there are some points that we should clarify in the Hungarian regulation. So I think we need a clarification in the future for this legal institution, but I think it's a good tool when an older owner of agricultural holder would like to take some steps for the future of the agricultural farm, and it can be a good tool for this. So these was my proposals, which I would like to highlight, and thank you very much for your kind attention.
Dr. Hornyak, thank you so much for your presentation. And after the Hungarian approach now, I'm absolutely curious what is in the situation in Poland in this sense. And I would like to invite Dr. Zala to deliver his presentation about the Polish legislation.
Ladies and gentlemen, thank you very much for attendance. I would like to, firstly, to express my sincere gratitude to the organizers, to the team leader, and to my colleagues from the platform for opportunity to work together and to make those contributions. What I would like to speak about today is the regulation and acquisition of agricultural lands and holdings in Poland. Similarly, like in Hungary, this is a very wide topic, and I would like to concentrate on three aspects. Firstly, I would try to make a very short introduction into the situation we have in Poland. Secondly, I would like to deliver a speech about the landmark regulations in Poland, the main regulations in Polish statutes. And the last one, and the last part of this presentation will be the lege ferenda proposals and, you may say, so-called good practices. So, starting with this very short introduction. Since the mid-war period, from the 1920, we had a regulation that generally prohibited foreigners or foreign legal entities to acquire not only agricultural but land as well, without the permission from the state authorities. The situation changed because of the accession of Poland to the European Union, and this law from 1920 need to be amended. And there was an amendment. There was still permission required for the abroad physical or legal persons. However, this permission was abrogated for the citizens or entrepreneurs from the member states or from the so-called European Economic Area or the Swiss Confederation, with one very important, very extremely important exception. This is the acquisition of agricultural land and forestry real estates. There was a 12 years period for this exception to be in force. And must be admitted that before the 1st of May 2004, before the accession of Poland to the EU, there were already some restrictions on the acquisition of agricultural land under the law from 2003. I will go with the abbreviation UQUR. It would be simpler. These restrictions was implemented irrespectively of the nationality of the acquirer. So whoever a citizen of the EU, a Polish citizen, or a foreigner would like to acquire agricultural land, this restrictions were still in force. These restrictions were mainly exempli gratia the preemption right granted to the lessee of the agricultural land. There was a period, especially 3 years period, the form of contract that was to be concluded, and if he or she didn't exercise this preemption right, the right was granted to the state treasury, and the same right called right to acquire, because in Poland there's a differentiation between the sale contract, and we speak then about the preemption right, and where other legal events took place, we are speaking about the right to acquire. But the effect is the same. The state treasury will be the owner of the land. And the expiration of that 12 years period mentioned earlier it created the opportunity to introduce new regulations on the agricultural land, new regulations aiming at some changes to the system of ownership of agricultural land in Poland. The aims of the legislator, of the lawgivers, were included in the justification of the project, in fact, amendment to the UQUR from the 2016. I will concentrate only. It is a very large document. Even this excerpt from this document mentioned here is long. I would try to highlight this bolded text. The reasons were that the agricultural land should be treated not as an ordinary land, but a public good, a non-reproducible good, and there is a need to introduce specific legal regulations. And one of the main goals of the lawgivers were to counteract the speculative purchase of land and then resale at the higher price, which will probably result in withdrawing many agricultural land in Poland from the agricultural use or from the free market. And of course, such regulations, such restrictions about the acquiring agricultural land will affect, for example, the right to property mentioned earlier. And in Poland, when we need to restrict the constitutional right, and the right to property is one of the constitutional rights in Poland, there is a need to find a provision in the constitution, in the basic law, that justified it, or the value that justified it. And in Poland, it is easy to find such one, or a provision, because in the Constitution of the Republic of Poland from 1997, there is an Article 23, where there is a regulation that the basis of the agricultural system of the state shall be the family farm. So there is a very, not implicit, but explicit grounds to put restrictions about the agricultural land. And from the original text of this most important law, most important statute dealing with the acquiring of the agricultural land, this is UQUR once again, there were changes in the aims of this law, and there was an introduction of the amendment, and you can see that the strengthening of the protection and the development of family farms was included, as well as the proper management of agricultural land. You may see that even previously, at the beginning of the coming into force of the UQUR, there was a counteraction for excessive concentration of agricultural real estate included already at the entry into force by this law. So what are these restrictions, as we had the most restrictive approach to the acquiring of the agricultural land? The main rule, in fact, can be seen in one article, one paragraph. This is Article 2A, Paragraph 1 of the UQUR, and the rule states like this: the purchaser of agricultural real estate may only be an individual farmer. Who is the individual farmer? It is a physical person, a natural person in this translation, who is the owner, usufructuar, holder, lessee of agricultural land, not bigger than the 300 hectares. But what is important, he or she needs to have agricultural qualification. He or it needs to reside for at least 5 years in the municipality where the one of the land that consists the agricultural holding consists of, and he or she needs to run the farm on his or her own. And I believe this regulation that is independently on the nationality of the acquirer or the farmer is probably one of the grounds that the Poland, there is no grounds to brought the case against the Poland in the European Union Court. This regulation in cohesion with the permission that enables legal entities in some circumstances to acquire agricultural land. And this main rule may not apply in numerous of cases. When during the project I have analyzed this very complex and wide regulations, I divided it cases in which the legal entity can acquire agricultural land, the cases in which this main rule does not apply, into 5 categories. The first category is the acquiring not agricultural land, because when we go back, the agricultural real estate, agricultural land is its definition consists of the real estate not located in the areas designated in the spatial development plans for agriculture purposes. So we may, even if the plot can be used for agricultural purposes, but in the special development plans, the aim of this plot is different, it's not agricultural, we can still acquire those land out of the scope of this regulation. The second possibility is to acquire out of the scope of this law, because there in the first provisions, in the first articles of this law, there is, for example, that it does not apply to the acquiring plots that are lesser than 0.3 hectares, or the local roads, and so on. 2 other exceptions are named object-based and subject-based exemptions. It deals with the situations basing and differentiated the situations on the fact who acquires or what is acquired for which purposes. For example, object-based exemptions are like this, for example, to build a wind farm and the subject-based exceptions. It is very important in my area of practice, namely the legal entities of churches and other denominational legal organizations, or the state treasury can acquire, of course, agricultural land without any restrictions. And the fifth possibility is the authority permit. It is issued by one of the administration entities of the state, and there are, of course, the prerequisites to issue such permission. We had to make a full picture. We need to say about two institutions. Still, the right to acquire and the preemption right to agricultural land. As you know from the previous slides, there were already regulations about it. However, there were, you may say, added some new and some amendments to it from 2016. And today's right to acquire agricultural land still considers the lease agreement, the lessee of the agricultural land must be performed for at least 3 years from the date, and it must be a part of the family farm. This is something new. A family farm is a farm run by the individual farmer, so all the prerequisites of the definition of the farmer are included, but is of a surface lesser than 300 hectares. And if this right is not exercised, the right goes to the so-called KOWR. It can be translated as a national center for the support of agriculture. This is the state institution. And then this authority is entitled to exercise the preemption right. On the other hand, when the transfer of or the acquirement of the agricultural land is due to the other legal event, not a sale contract, but for example, acquisitive prescription or the legacy bequest or something other legal event, there is a right to acquire, and this is also to the tenant or to the state institution. And to summarize, what may be the legal referenda proposals? In fact, when we think about the protection of farmers, as in Poland and in Hungary, we had the most strict approach to the question, to the issue. It is very difficult to formulate how to protect more the farmers. So the proposals deals mainly with some of the technical issues, and the good practices are derived from the already existing regulations. For example, what can be say to other lawmakers or lawgivers, legislators. I believe that in introducing the maximum area of agricultural land that can be bought without further restrictions is a good way. Maybe 300 hectares. We can discuss whether it is too much or too less. However, introducing boundaries in which we can acquire agricultural land without restrictions is very important. And one of the issues, one of the good practices included already in the Polish legal system that I strongly agree with is the granting right to acquire, the preemption right to the lessee of the agricultural land, because we have when someone conducts agricultural activity for 3, 4 or 5 years already, we can assume that the agricultural land will be used for agricultural purposes and not only for the making worth with the resale of it. So speculative acquired. And third good practices derived from this regulation is the rule that the individual farmer can be the primary or the only acquirer of the agricultural land. However, of course, there must be some exceptions, and only if it is in the coherence with the preferred model of ownership, is a political will, and of course with the basic law provisions. If we have no legal grounds to introduce such a rule in some country, we simply won't be able to introduce. We in Poland had this Article 23 and the rule that the family farm is the ground for the agricultural system of land in Poland. As far as the not good practices, but the postulate, the referenda proposals or the suggestions, I would like to divide them into the two categories. The first category is more the formal one. It deals with the issues with the theoretical principles of the system of law, especially the cohesion of the system of the law, and I'm sorry. And I believe that simplifying the structure of the text, which is already very complex, there are many references. It can be reorganized for farmers to be easily read by the addresses of the law. And the other thing is the definitions. I believe that we do not need, there is no necessity to create two new definitions of agricultural real estate and new definition of agricultural holding. It will be suitable enough to reference to the definitions from the Polish Civil Code, and other prerequisites that modify the definitions can be simply put, for example, into the regulations on the scope of the UQUR. So, because there is no need to introduce very new definitions into our system of law. Another thing is to omitted the agricultural holding in one of the regulations because it is, in fact, this article deals with the agricultural land and not agricultural holdings, and there is no necessity to reference in the regulations about the acquisitive prescription. It is the Article 210 of the Polish Civil Code, because the scope of this article, acquisitive prescription, is already included in the regulations of the UQUR. As far as the substantive content of the regulations are to be concerned, I believe there is a need to restrict the scope of the reference to UQUR in articles, in this article mentioned here, 172, only to land area more than 1 hectare. There is a need, for example, to restrict this acquisition on that special grade acquisitive prescription in the case of very small plots, for example, small plots that are smaller than already 0.3, for example, very, very small things. And one of the propositions that I strongly recommend is to include the ordinary bequest as an exception for the rules, this main rule of the UQUR, because there is an exception concerning the other kinds of the legacies in Polish system, and it's omit only one kind of this, and I believe there is no grounds for the differentiation between these two systems. And the third one, it's probably the most to be disputable one from this, is whether we need to introduce the absolute invalidity in the case of violating the rules of the UQUR. I looked through the statistics in what occasions this right to acquire or the preemption right was exercised, and it seems from the statistics is only one of the branches of the KOWR that is the minority. Maybe it is a good proposition, not at least to consider it, whether the nullification of the declaration of the state authorities, this situation, this change will affect only the contracts in which the state would like to enter as a purchaser, and not all the acquire contracts in Poland and other kinds of legal events. However, this needs to be assessed further as we have now more reliable full statistical data. Thank you very much for your kind attention. Once again, thank you.
Dear Doctor, thank you so much for your contribution. Ladies and gentlemen, as you can see, our panel was quite thoughtful. Therefore, we tried to determine potential ways how to improve the legislation issues, even at international, European level, and of course at national level. But now, as the program, it is high time to ask you whether do you have any questions to my colleagues, or maybe to me. In this case, I would like to call Professor Vielec to do what he has to do.
Dear friends, ladies and gentlemen, another pleasant moment. I handed the certification to another members of another group. Mr. Professor Janusz Szilagi.
Thank you so much. Thanks a lot. Thanks. Very nice.
The second person, it will be Dr. Martin. My name.
Yeah.
Sirishki. In the Hungary, Martin is the same.
Yeah. Thank you.
Martin, please.
Thank you very much.
Thank you very much. The next person, Mrs. Zofia Hornia. Zofia, thank you very much for your participation. Thank you very much. Please.
Thank you.
And the last person, Dr. Marek Strzała. Marku, thank you. Dziękuję bardzo.
Dziękuję.
Coffee break.